So we have with us Honorable Mr. Justice Rajiv Sahay Endlaw. Thank you. Mr. Vikas Goel, Senior Partner, Singhania Partners, and Ms. Payal Khanna, who's the Director Legal and Compliance at Volvo Cars India. Thank you for joining us today. So I would like to briefly introduce our panelists for the day. Uh, Justice Rajiv Sahay Endlaw is an alumni of Campus Law Center and Hansraj College, University of Delhi. He was appointed as the High Court as a permanent judge in Delhi High Court in 2011. Initially, he practiced in a solicitor's firm for 3 years and thereafter practiced law in Delhi High Court and subordinate courts. His colleagues and juniors fondly remember him as a judge who, even in the most unremarkable of matters, consciously sought to achieve balance between battling pendency, securing justice in the facts of the case, and weighing the consequences of the acts of justice. He retired from Delhi High Court in August 2021. Our senior partner, Mr. Vikas Goel, he did his BCom honors from SRCC and LLB from University of Delhi. Later in his career, he also pursued LLM from University of Delhi, or from Kurukshetra University. In his career spanning more than 25 years, he has assisted numerous infrastructure companies across various facets of disputes. And amongst other things, he holds the record of writing maximum number of articles on the arbitration and disputes issues in our firm. So today we are also distributing a copy of this book, Arbitration Dossier, with a focus on infrastructure disputes. So this is a compilation of articles with disputes around infrastructure sector, international arbitration, and some interesting judgments are also quoted in this book. And a lot of these are written by Mr. Vikas Goel. So if you would like to have a copy, it is available at the registration desk outside. Yeah. Lastly, I would like to introduce Ms. Payal Khanna. She is Director Legal and Compliance at Volvo India. She has overall 16 years of experience working across prominent Indian law firms and has in-house legal counsel in handling diverse and complex legal issues. She has handled general corporate matters, litigation support for various sectors such as FMCG, automobile, real estate, oil and natural gas. She has previously worked with PepsiCo India, where she led the project for GST implementation. Payal is a Delhiite, a mother of two, and a second-generation lawyer. Both her parents are lawyers. It is an honor to have you all here. Now, may I request Mr. Vikas Goel to please present a bonsai plant to Justice Endlaw. So, and a copy of our book on white-collar crimes in India for Ms. Payal Khanna. Thank you. Thank you. Over to you, sir.
After the first interesting session on expert testimony in arbitration and getting useful insights there, now we move on to this next session, which we had initially categorized as can non-signatory be bound by arbitration. So first, I would like to clarify this should be understood in the sense that we are talking about a scenario where there is no arbitration agreement between the parties, and can such a party be bound to arbitrate? That is the bottom line. Now, if one look at the topic itself, one may say that if there is no arbitration agreement, so why there is a discussion? There is no meaning of arbitration, then you can't force the party to go to arbitration. But there are certain circumstances and scenarios which we will discuss, and we'll take the opinion of our speakers, where you will see that the answer can't be yes or no, and most of the time it is maybe. So how do we handle those situations of maybe? That is what we are going to discuss. So with this brief narrative, I think we can speak. I can turn to my speakers and ask the first scenario, sir, regarding the non-existence of arbitration is a situation. What happens is during negotiation, parties exchange draft agreement which contains arbitration agreement clause also. but finally the agreement is not executed, and somehow parties proceed with the transaction. They issue invoices, etc. But when the invoice comes, when the disputes arise, they want to rely on the arbitration clause. So how would a court look at such a scenario, such a dispute? Because actually speaking, the arbitration agreement never came into existence, but one of the party wants to rely on it. How the court would look at such a scenario?
See, under the new act, first of all, thank you very much for having me here and for hearing me for the next few minutes. I know everybody's time is precious, so it's really a great privilege to be here amongst all of you. Now, coming back to the question, what Vikas has put, see, under the new act, in fact, recently the Delhi High Court has reiterated that there is no requirement of a signed contract. So, if the arbitration agreement can be deciphered from the exchange of letters or exchange of correspondence, then there can be construed. But save for saying that, nothing can really be said certainly about this, because it depends upon so many things. If there is no signed agreement between the parties, as Vikas said, then definitely there is no agreement. That would be the first thing. But if what were the clauses which were mentioned in the agreement are referred to in the subsequent correspondence between the parties, and from the entire correspondence it appears that the parties have proceeded to transact in a way as if that agreement had been signed into, and non-signing of it is not intentional, but only a lapse or for XYZ reason, then the finding would be that yes, the parties are bound by the arbitration. So it's really a very factual question, which depends upon the kind of evidence which is placed before the court. Ideally, what I have seen in the last 15 years is that the way in which trade and commerce, particularly the trade and commerce which all of you represent, is done has totally changed. So today there is nothing left verbal, there is nothing left that it remained or something. So primarily the judge would start, or the arbitrator would start with the thinking that yes, the parties did not want to sign the agreement and therefore there is no agreement. Because what I have noticed today, that even people sitting in the same office, that is one of the parties, they are not speaking to each other verbally. They would not get up, sitting in neighboring cubicles, they would not get up and ask anything. They would email to the next desk and the next desk would reply. So once it is so, because this is more so in commercial contracts where there is a requirement to reveal everything and to make a disclosure. In the last few years of Commercial Courts Act, when I had a chance to oversee these disputes, what I found is that if a proper disclosure is made, and which can be made, because the links are missing if you try to conceal some email. So if somebody scans through the entire documents relating to the contract produced by a party, one can find out that something is missing. And once you see it, so if there are emails in one party's office which are to the effect that, look, this is there, this is the agreement, or this is the reason why it was not signed, or we were intended to be bound by it, then definitely. Thank you.
Sir, because I was referring in the context of this judgment which I read, Praveen, in electricals, what has happened is initially High Court appointed the arbitrator saying that there is an arbitration agreement. When the matter went to Supreme Court, it was argued for a number of days, and I could see from the appearances who all were appearing. Now, ultimately, the court said that, okay, I appoint an arbitrator, go to the arbitrator, let the arbitrator first decide whether there is an arbitration agreement. So, my point is, from a client's perspective, would this not be a futile exercise if suppose tomorrow arbitrator again comes to a conclusion that there is no arbitration? So, substantial time, money and effort has been wasted in that exercise. Same can be done at the stage of the court itself.
See, Vikas, you touched the nerve of what I intended to address today, all of you on. Now in this forum of Confederation of Industry and the legal practitioners or the legal councils, according to me, we should not be discussing, or this open house should not be on open house on legal strategy for infrastructure contracts and disputes, should not be on can non-signatory be bound by arbitration. You should leave that for the judges to decide and arbitrators to decide. That doesn't concern you, can they be bound or not. What all of you should be debating is, because the answer, as Vikas also said, is no, they cannot be bound. Non-signatories cannot be bound. What you need to see is that why did your action, when I say your actions, I mean because this question arises from the contract signed by the parties and which contracts are drafted by the legal practitioners and legal counsels and general counsels. So why did that question was required to be decided by the courts? The question was required to be decided, according to me, because of the fault or the default committed by the parties in addressing an agreement or in signing an agreement or by the legal practitioners. The attention which is required to be paid, and I am very passionate about this subject, I have commented upon it several times whenever I get a chance about it, the entire fault which lies with arbitration, because arbitration is not a very happy scenario today. Let's all accept it. In fact, that most of the write-ups about the ICC, they are very worried about arbitration being a dying subject, that they feel that international commercial arbitration has outpriced itself and slowly people are not opting for it, and that is why you've seen the setting up of the international courts in Singapore, which Justice Sikri from India is still manning. And slowly such courts will come. I believe Dubai has come up with a international court. So people are going back to the court system from the arbitration system. Now the problem is that, see, arbitration is resolution of disputes by a forum of your choice or by a person of your choice, rather than the default part of if there is no dispute resolution mechanism provided in the agreement, the resolution is by the state appointed courts. So they have a well-defined, well-oiled machinery about it. Now, why do we want to opt out of it? We want to opt out of it because we want a more expeditious, and I'm sure one of the considerations is a cheaper system of adjudication. Now, when we draft the arbitration clause, we merely lift it from some other contract. We are not paying attention to that. What are the disputes which are likely to arise? And if the parties and all of you apply yourself to that, what are the likely disputes which can arise out of this contract, you will have them before you, like with so much clarity that you will be surprised. And then you have to see that, all right, if we have this kind of a dispute, I want it to be decided by lay in this manner. This would be the criteria for deciding it. Like I heard on the expert panel that there is a variation on valuation. There are so many methods of valuation. Now, why can't the parties agree that, all right, if there is a dispute between us, we'll adopt this system of valuation, which is well recognized. It's just that the parties are failing to apply their minds at that time. One of the speakers in the earlier session mentioned about the rate of interest. Now, rate of interest is also not such a big thing. You can always provide that the returns yielded on the amount by the A-listed mutual funds, or the return yielded on such and such stock, or on the previous year's profits of so many years of party A or party B. So that will lead to all the delays being curtailed, the arbitrator knowing that how exactly the dispute is required to be settled. So now, sorry, I'm taking a little longer, but I think all the other questions can be directed to Payal after this. But this, I felt, is the crux of what I can contribute to the subject. The thing is that, now, why did the courts get to decide? In Chloro, I think the two major judgments are Chloro Control and Amit Lalchan Shah. Now, Amit Lalchand Shah, I had occasion to decide as a single judge, and I was overruled by the Supreme Court, so I'm more conversant with the facts of that case. So I'll place the facts of that case. Now, Party A and Party B are entering into an agreement for a single project. Now, that project has a lot of complexity, as I'm sure all the projects or the contracts which all of you are mostly entering into today. Now, the taxation planning was very good of both the parties. So they decided that, all right, instead of the entire project being done in one single entity from both the parties, one party created 5 entities, taxation entities, another created 2 taxation entities, and the project was split. Now, in 2 of the contracts, the arbitration clause was provided. In the other 3 contracts, so there were 5 contracts of which only 2 had a arbitration clause. Now one would, and the working of the 5 contracts naturally was overlapping each other, that the delay in one could not be decided without taking into consideration the other. So now I don't really know it. According to me, it was a lapse. It never came out till the end. And when disputes happen, that bonhomie which is there at the time of entering into the agreement, that naturally is not there. So one party wanted arbitration, the other party didn't want the arbitration. For XYZ reason, the other party felt it had a better chance in the court than before the arbitrator. So that is why that question took 4 years to decide that why should it be. So now what you said, that the question, the short answer to that is, see, the courts have to interpret the law. The arbitration law is of party autonomy, and the ancestral model is that the arbitrator decides his own jurisdiction. So the way the law has been interpreted is that the court will give a finding as to the existence of the arbitration agreement only if it can be deciphered very clearly. But if it is not clearly, if it requires investigation, then that jurisdiction is of the arbitrator only. So again, I would say the parties cannot be heard to complain of this, that it costs money and time, because all of us as legal practitioners, as an industry, and parties to the contract are to be blamed for the situation. Thank you.
Thank you, sir.
Now
Let me ask Payal, what would Payal
I
Khanna do?
overshot my time.
No, sir. What would Payal Khanna do in a situation of a client where, you see such a situation that you can possibly go for arbitration also, and once you invoke arbitration, the other side says that there is no arbitration agreement. So would you still want to test that existence in the court of law, or you would prefer to file a suit in such a scenario?
Yeah, thanks. I think this is a pain that most of us corporates lately sort of have to face. I think we all as lawyers want to do the right thing, want to follow the law, help the company get the right thing, but I think we have our own justifications to be done to the business teams who are always sort of questioning us as lawyers that, does it really make business sense to, spend so much of litigation cost? I know the initial concept of arbitration, sir, when it came in was that it was more like a speedy way of expediting any dispute between the parties as compared to getting into regular courts. But more coming from a practical scenario where I have been handling multiple arbitration claims in my tenure here at Volvo. I think each claim is very unique. In fact, I was telling Vikas before this session that every claim I find a uniqueness. And coming back to the question, what is there, sir, that if there is no clause in the agreement, do we really get into the courts to do it? I think as a general counsel of the company, I will always advise that let's not get into it. If there is no clause, let's just not.
Or there is any doubt.
Yes, because I do see, sir, that there has been a decision lately which says that even if there is no signed agreement, then you can always interpret through the emails or through exchange of letters. But usually as general counsels, we advise our business teams to always sign a contract, because I think that's always foolproof. you know, I think I will like to rather say that from my perspective.
Okay, thank you. Sir, there can be another scenario, and again, I'm discussing it from a perspective that in such scenario, we find at some stage, the arbitration agreement is missing. Maybe initially the intention was something else. So another scenario could be where the parties have actually entered into an agreement which has an arbitration agreement, but that gets superseded by another agreement. Now, at the time of drafting, again, maybe it is a council's mistake or something like that, the new agreement does not have arbitration clause. Now, once the dispute arises, again, one of the party wants to go back to arbitration. Now, the question would arise, in my understanding, whether this dispute relates to the superseded contract or the new contract, and depending on that decision, sir, the court may perhaps take a call as to whether it is arbitrable or not, or there can be some other way of looking at it, sir, where the contract gets superseded.
See, the test again is whether the second contract is a supplementary or ancillary contract, or it's a novation of the earlier contract. If it's a novation of the earlier contract, or it's in substitution of the earlier contract, then any clause of the earlier contract cannot be incorporated in it. It's not a question of inconsistency, though in one of the recent judgments, the Supreme Court took note of this fact. Because you see, Chloro Control and Amit Lal Shah are both cases where some agreements forming a part of group of agreements between parties under the same management had an arbitration clause, and the others did not have an arbitration clause. But recently, the Supreme Court has been faced with a situation where each of the agreements had an arbitration clause, but the arbitration clause was different. In one case, say, sole arbitrator, in another case, a panel of 3 arbitrators. So there, they have not agreed with Chloro Control and Amit Lal Chand Shah.
Sir, what would be the situation if, again, we see this kind of a scenario, like there is a main contract, and this happens mostly in the infrastructure contract, where the main contract with the authority is signed by the main contractor, and then part of the work is assigned on subcontracting basis. Now, when we look at the subcontract, we find that it does say that the performance of subcontract would be as per the terms and condition of the main agreement, as also the specifications. But the question then again is whether the arbitration clause gets incorporated into the subcontract, because the subcontractor wants to raise a dispute against the main contractor and wants to rely on arbitration clause. So what would be the scenario in such a case? Would the court look at specific incorporation by reference, or a mere general reference that all terms and condition of the main contract would be applicable, sufficient?
See, the answer, according to me, except in peculiar facts, would be no. That arbitration clause between the employer and the contractor cannot be read into the contract between the contractor and the subcontractor, even if it is done on a mutatis mutandi basis. A lot of times what happens is that the arbitration clause between the employer and the contractor would have a resolution, mediation mechanism. Like I think NHAI has that dispute resolution committee, now which would be missing. So if that is the precursor to the arbitration and there is no dispute resolution committee between the contractor and the subcontractor, notwithstanding mutatis mutandi, it won't be there. So the answer has to be again no. But these are all, I repeat myself, are lacunas of drafting and not enough attention being paid by the parties. So you can't be hurt to later on say that, look, my arbitration clause has been wasted or I have incurred so much expenditure. In fact, one of the cases before the Supreme Court, which I think went on for about 10 years, was that it was a consortium of 5 which had entered into an agreement with somebody else, and there was an arbitration clause in that agreement. And the dispute which was raised was by only one of the members of the consortium against the other party. So it took 10 years to decide whether that should be.
That was my next question to you.
Oh, okay. So arbitration clause, if you read some of the authors, is described as the midnight clause. I don't know whether in practice it is true or not. What the authors there say is that after the parties have negotiated all the commercial terms, they are exhausted. It's already 11 o'clock in the night and they are waiting for the drinks. Then they say, "Acha yaar, wo ek arbitration clause bhi dal do." So it should not be treated like that.
Let me ask Payal. Payal, do you face this kind of a situation in your practice where, you know, because you are an Indian company, there is a foreign parent company also. Have there been an attempt by an Indian party, maybe your dealer or customer, to implead your parent company on the strength of the agreement by saying that they are the real party, and maybe with the aim that if they are impleaded, they get a better chance of settlement?
Yeah, we had a very unique situation, and it was just when I had just joined Volvo. There was one of the arbitration claims. Of course, we have a lot against our dealers. So we don't sign any contracts with our headquarters, which is Volvo Car Corporation in Sweden. So, but apparently, since we are a globally owned brand, the dealer felt it would have been right to implead them as a party, because they felt that they are representing Volvo in India, which belongs to a Sweden party. So that was their case. So while technically the local contract was purely between the legal entity in India and the dealer, and of course every business operations, every transaction happened between both of us. But I think you know how it is when the claim is filed. The dealer tries to, you know, inflate the demand and make the claim and try to do that. So they tried to further implead our parent company as a party. Obviously, that was strongly objected by us, and fortunately, we were able to succeed to not include the headquarters as part of our party, purely on the reasons that you know, they have nothing to do with the local operations. So yes, we have had those situations, Vikas.
Okay. Now, sir.
I may add, Vikas, you know, no case against Google, to my knowledge, is filed in Delhi High Court without making Google LLC a party.
In fact, I was just telling Vikas also, not just arbitration claims, in all our consumer cases also. I don't know why they also make Volvo Car Corporation also as a party. So we have to file the whole pain of getting us authorized in India and then doing it. So it's not just limited to arbitration. It's also consumer cases as well.
Also, yes.
Yeah. And when you go down in West, when you go down in Europe, for them this has a very different sanctity. You know, in India, we are still very, you know, acceptable, this happens and all that. So when I joined as a general counsel in Volvo, the first thing I had to convince and explain my foreign colleagues was that it's all right to have being made a party. There's no risk, you will not go to jail, so don't worry. It happens in India.
It happens. It happens only in India.
You are being sued. Very serious.
Yes, yes. So down in Europe, they take this in a very different context. So that was, I think, the first thing I tried to convince them. It's all right.
Now, sir, coming back to the issue of consortium, sir, like two members in the consortium, they sign an agreement with the authority. Now, it happens that by the time the dispute arises, one of the consortium member is only affected and the other one has no grievance at all. Now, will he be entitled to rely upon the arbitration agreement which has been signed by them jointly, or he will be asked to necessarily include his partner before invoking the arbitration clause?
I've already said that the decided case is that, yes, one of the consortium members alone can sue. I don't really recollect in that case whether the other 4 parties were directed to be pleaded as respondents or not. But as a civil law practitioner, I would say yes, that's the proper course, that they would be proper party if not necessary party.
And sir, what would be the scenario in case the authority has a counterclaim and that counterclaim is against both of them, not only one?
That they are entitled to, since the arbitration clause is there.
Yes.
So they can be. In fact, one of the issues which was being agitated in another fora where I had occasion to be present was that how counterclaims are made for the first time after the arbitration has been invoked by one. And the view which was emerging as a better view there was that no, if you have not made a claim, you should not be allowed to make a counterclaim. It's only as a way of counterblast.
Counterblast. And this practice, sir, I have seen it is increasing. Nowadays, government authorities are also making counterclaim, and the counterclaim value is far more than the claim which is made by the contractor. Maybe it is just to based on some advice. Now, sir, another situation which we face in some scenario is that the party, when they sign the agreement, there is a change of status. Like when I signed the agreement with one party, I was sole proprietorship, but by the time the dispute arose, the sole proprietorship got converted into a partnership, or let us say a company. Now, the arbitration clause is in fact invoked by the changed entity, which is either the partnership or the proprietorship, the company, new company. Would they be entitled to invoke arbitration because they have not signed? It was signed by the sole proprietor concerned. And this is something which we are facing in practice also. We are objecting to this.
It is again slightly factual, because most of the agreements, especially where expertise is involved and which is there in infrastructure contracts, they have a clause about non-assignment except with the permission. So if the contract was given to A and A has established a limited company in which he remains to be associated, the limited company, though under the control of A and under the expertise of A, would still be a different legal entity and would not be bound unless specific permission is there, or permission can be deciphered from the case. A lot of times, one case which had come before me, that was very typical, in that the contract had been executed, and after that the sole proprietary had been converted into a private limited, and forgetting that the sole proprietary invoked. So in that case, of course, it was held that arbitration cannot be invoked by the limited company.
By limited company.
In fact, to that, sir, how we usually practice in companies is whenever there is any change in ownership or change in the shareholding party, we always ask for the amendment to the contract. Yeah. So we always ask that if party A signed the contract, and now, of course, you have situations of mergers, you have situations of acquisitions. Not just only with that, we always, as in-house counsels, ask that let it be an addendum to the contract with the name of the new company.
New entity, yes.
Only then it will be holding legal footing. Otherwise, I think, sir, that hold goods even in the courts, that it has no sanctity otherwise.
See, in case of mergers, the scheme sanction usually
provides for it,
that all contracts stand transferred.
Yes.
So there, the situation may be taken care of that way.
Like, sir, in the case that I am mentioning, there the situation was, the party was a sole proprietorship, the other party, and by the time the dispute arose, it became partnership. And the sole proprietor was the partner there, but between the time the dispute arose and the last transaction, there was a lot of gap, and there was complete coitus. And when they initiated arbitration, the arbitration was initiated by a partnership concern. So the issue arose whether they can really do it or not. So that is what we are challenging, that because there is a change of status, you can't do it.
No free advice.
No free And sir, now coming back to Amit Lachan, sir, and this group of company doctrine, where which is the, I would say, one scenario where the courts have repeatedly held that even if one party is not a signatory out of many, then they can be bound, they can be compelled to arbitrate. Now in Amit Lal Chand, what I could see and what is the issue that comes to my mind after reading that judgment time and again, lot of emphasis is on the fact that there is a main contract and the main contract had the arbitration clause, and that is why the ancillary contract should also, the intention should be read that way. Now, but when I read the judgment of the Supreme Court, I found that the High Court was not saying the same thing. The High Court was at, there was a difference of opinion as to what would be the main agreement. So my question to you is, in application of a doctrine of group of company doctrine, is it really material to first find out what is the main agreement, and secondly see whether there is a main arbitration clause, and then only can any decision be taken, or it is not really a very significant issue?
I scribbled a few words which I thought the principle which I was laid down in the 2-3 judgments of the Supreme Court which are relevant on this subject are, the first of course is that arbitration, being a creature of the contract, does not set well in binding a non-signatory thereto. Then why in Cloro and Amit Lal Chand Shah they went the other way is because the court was attempting to maximizing the award's practical effectiveness by binding non-parties thereto, and for the reasons of economics and convenience of the parties. So the spirit which prevailed as per my reading of those judgments, and especially Amit Lal Chand Shah, in which I was overruled, was that we are imputing that intention, though the Arbitration Act does not use the word implied. So the court avoided using the word implied agreement, but you took advantage of the phrase which occurs in section 7 of the Arbitration Act, claiming through or under. So they said that the claims under the other agreements were also through or under. So maybe that would explain why you are saying that they had to go into the main contract.
Main contract, yes.
But otherwise, each of the contract which is entered into, for instance, in that case, it was a solar power plant. So one contract was for supply of goods, the equipment. The other was for installing that equipment. The third was for
leasing,
maintaining. The solar plant has to be maintained. And the fourth was of selling, the next was of selling the power. So that is how one single transaction, which could have been by one contract, was split up into 5 contracts.
So that really doesn't matter.
So according to me, main or non-main would not be, but if the Supreme Court has said so, and again I emphasize that the court was required to step in and do this because of the fault of us legal practitioners and parties to the contract. We should have taken care of that. So what I want all of you to go back with today is to ensure that this kind of a situation does not arise and you don't spend time and money, as you said. Though I'm reminded of an anecdote. As you were told, initially I joined a law firm, so there I was given the portfolio. I'm talking of 40 years ago. There used to be a lot of written opinions at that time because the corporates didn't have legal counsels like all of you. So there, very large corporates would have a legal aid, but he was also more like just for marking the matters or sending for opinion the questions which arose. And the firm in which I was working, we had a lot of autonomy, like in arbitration, that I was barely a year old, but I was told unless you need somebody else to be consulted, you keep on sending your opinion. And we used to have about 7 or 8 opinions in a day in writing. And so one particular client, I kept on sending opinions, and then one day I was called into the partner's chamber and the partner was not there, and some person very heavy built whom I did not know, had never met, he was there. and very old, much older. And it turned out he was the legal head. That's how they were called at that time of the group. So he had a folder in which I could see all my written opinions. So he went through that. He said, "Barkodar, लिखते तो अच्छा हो, पर अगर ऐसे ही करते रहोगे तो क्या तुम खाओगे और क्या हम खाएंगे?" So you have to be careful of that also.
Sir, another issue that I wanted to check with you was, as I read these judgments, particularly relating to group of company doctrine, the court lays lot of emphasis on this fact, provided this is available in some cases, that one particular person, like there are 5 companies, and there is 1 or 2 person who are commonly authorized for all these companies to arrive at the common intention issue. Now, how that can be done when, more particularly, when the settled legal position is that company is a separate legal entity and authorizing somebody does not really matter. Anybody can be authorized whether he is an employee or not.
And I think I have spoken sufficiently on this. No, you please, you go ahead with your thing on this.
Maybe she can
Yeah.
after that.
See, again, it becomes very, very factual in both the cases, and I have not really read about 3 other cases of the Supreme Court in which this group of companies, I am primarily addressing on the basis of Floro and Amit Lal Chansa. See, different legal entity was given a go-by. In both the cases, each of the company was a different legal entity. What was necessary was the common management at the end of the day, the common control of the shareholding and of the running of the businesses of all the entities. So that was the spirit in which, and the single nature of the transaction. So a distinction has to be made between a single transaction and allied or connected transaction. Because what you said about subcontractor, now that's a case of a connected transaction. There was another judgment I was reading, I don't know. Yeah, in that what had happened was that one of the companies which had to source a large number of, which had to purchase, I guess all companies have to purchase. They entered into an agreement with a financing company that you will give credit to all our suppliers so that our creditors get their payment immediately. And that contained an arbitration clause. And then the suppliers were not compelled to take finance from that company, but because very favorable terms were being offered, so most of the suppliers started taking credit from that financial company. And then a dispute arose between the supplier and the financing company. The supplier must have defaulted, and I think they filed a Section 11 in Calcutta as per the jurisdiction of that contract. And there was also some dispute between the financier and the, the manufacturing company which had entered into the other contract. So the payments from one to one, and they were stuck up like this. So the attempt was made in the Delhi High Court to have one arbitration only instead of 2 arbitrations. Now they were totally allied, interconnected contracts, and same chloro control and all were debated, but it was held no, there cannot be one arbitration. It will have to be separate arbitrations under both the clauses.
Payal, what is your view on this?
I think I have quite similar understanding what Sir has just echoed, and I think that's we continuously reinforce as well within the organization that they are independently governed by the specific clauses in their contracts. You can't say that one is impliedly relevant to the other. So that's, I think, we also quite aware of the situation, and that's why we continue to educate the business teams internally.
Actually, what is happening in practical reality, we are doing one matter, and it is again a contract for construction of a building, and we are representing an architect. So there the other side, who was the owner of the building, once everything was done, now they have raised a dispute with all the vendors, whether the architect, whether the construction contractor, other vendor, etc. So they are also trying to bring, using this Amit Lalchand, etc. argument under the same arbitration. So which is not really the intention of law, because every party is separate in its own, has own right under the agreement. So, sir, with this, I think the consensus is that if there is no arbitration agreement, except in the case of group of company doctrine, there cannot be an arbitration. Parties cannot be compelled to do arbitration. And also, I must add, before I ask the participant to put question, the Supreme Court has again referred this matter to a larger bench to examine as to what exactly is the legal principle, even in the for the purpose of applying this group of company doctrine, because now, as of now, court says that it is being applied more as a tool of convenience, and there is no legal basis. So, matter has been recently referred to a larger bench, and hopefully they will come up with some parameters based on which we can decide whether this doctrine has to be applied or not. With this, sir, with your permission, I can open the floor for questions.
Except that you will be eating into your lunch or the next session.
Not really. If anybody has any question, please.
Mr. Justice Endlaw has emphasized that we are responsible as lawyers and legal counsel to draft properly the arbitration clause. But my question is, when we are dealing with public sector clients, there's already an arbitration clause inbuilt in the RFPs and tenders. And we have very little say in negotiating that clause. So how to deal with such situations?
See, that I'm afraid nothing can be done. Your expertise has to come only where it can. Where it cannot, you have no choice.
Where the party is receptive to your ideas.
Yeah, I think usually these are all one-way contracts. Yeah. So you don't have much room to negotiate, especially in those standard clauses. I mean, you mostly can negotiate on the commercial terms, but these, I think, even my experience has been the same, sir. It's very difficult to get your way through unless you're at a very strong footing.
No, sir, what he's trying to say is perhaps...
How can we improve the quality of such arbitration clauses if we have to accept these clauses as they are? It's a dichotomy. We have the intention to improve upon these clauses, but we don't have the arms and tooth to do that. Or even the pen in our case. You
have to invite them to
seminar
forums like this.
So on a very crude way of saying it, and especially when we deal with such situations in houses, many times you end up into a mess, and that time the business learns. So next time when they're in a situation like this, they will themselves learn that why that clause was so relevant, and they need to change it. So I think many times, in fact, in our corporates, we have gone back and seen some typical clauses like this when it didn't work in a situation. So if things go well, everything is good. If they don't, then it gives situation of reinventing it.
Yeah, okay.
So there you have to suffer it, enjoy it.
Exactly.
Yes. Thank you, sir.
Sir, if I can add to that. We had, of course, we also worked a lot with public sector. I think the right entry point to address some of it, even if with some hope, is at the time of pre-bid meetings. So typically there is an industry consultation these days. That has become very popular. So even before the RFP comes out, there is industry consultation, and then there is a pre-bid RFP queries, and then there is of course pre-bid meeting. So those may be some places to think about. Of course.
Actually, the problem is, I tell you, what our experience has been, that because most of these public authority get funding from international funding institutions, so their contracts are already approved from them. Like, for example, we have seen DRB mechanism. It is not serving any purpose, except that time is wasted, and then we again go, both the parties, they don't accept the recommendation of the DRB, still they adopt that process. And the only reason they do it because the funding agency want those clauses to be incorporated. Maybe they have a different idea about it.
You are right. I mean, if it is a FIDIC or some kind of standard
Yes.
contract, then there is less chance. But even the funding, like I work with the World Bank, they do have inputs at the time of standard documents. So during every few years there is a refresh. So maybe some
They can
consultation. Yes.
So maybe he can try advising that to the client. Yes, you want to ask something again? Yeah, please.
Certain obligations on such public sector clients, that how they have to deal with the questions that are raised at the pre-bid stage, pre-bid query stage. Because in most of these pre-bid query meetings, these questions are brushed aside by stating that the tender condition would prevail. They don't go into the logic that is advanced for amending or carrying out amendments in the existing clauses. So unless we have some guidelines available from an autonomous body or from the courts under certain judgments, I don't see that these pre-bid meetings are going to, help all the stakeholders.
I don't think the court can lay down any such guidelines, but yes, CII can definitely take it up. It's one body.
Sir.
So, Mr. Singhania, we'll go back with a lot of work today.
Yeah,
Thank
if I
you,
can
sir.
add a perspective. So I happen to be from a public sector unit, and perhaps I might be able to offer the perspective on which I do sense a lot of people have a very negative opinion of. So let me first state the experience of various kind of odd clauses that you would often see in these documents are based on experience. They are not out of thin air. We do literally thousands of contracts per day, the government as a whole, and therefore the standard clauses which do get framed don't get framed by individuals like me. There are experts appointed who draft out these clauses, and they go through a process of review which has experts from the industry as well. So let us not imagine that those contracts are construed that way because we are like bad people. So that's one thing. And secondly, let me emphasize that yes, the pre-bid stage is an important stage. Please put your point forward. It might not change in this contract and the next and the one thereafter, but a continuous sort of a feedback to any industry always helps. Just that's my limited information.
Great to have you all today.
Let me just add two bits to that. You know, a lot of when we act both for the government as well as for the private side, and both of them are here. So, so looking at that situation, sometimes the medicine itself becomes a bigger problem than the disease itself. And the government as a whole, when they're acting on so many, like signing so many new contracts every day, and as each problem arises, they try to fix the problem, and sometimes the problem, instead of getting fixed, creates a bigger problem. So where there is a sense of distrust, there is a sense of insecurity, or they're trying to facilitate the situation, in the end it results in sometimes, but I guess what Mr. Sinha just said, as you continuously grow to raise those issues, it's only then you can get an answer. If you don't ask the question, the answer is no.
I had worked with NHI for 20 years, and post retirement, I had worked for World Bank, and I want to share my experience. So while working with NHI, I had the fortune of working with different types of contract. So pre-bid is a very important stage, and the NHI gives importance to that. And they, many times when there are so many pre-bid queries, they do a second pre-bid also. Suppose in the one pre-bid, there have been so many queries which alters the main contract. So they will do a second pre-bid query. So this is one aspect. Secondly, the World Bank and the ADB have a right to dictate their terms as per the Ministry of Finance circular. But NHI has been telling them we want to make it more to the present context. And the World Bank has been cooperative. I have seen in my own career with NHI many times the World Bank has agreed to the terms which are internationally they don't accept. After retirement, the World Bank appointed few experts, including me, to do a review of contracts of NHI and more, CPWD, GAIL, etc. Because this was for the purpose of ease of doing business. So when we reviewed the contracts, we found the system is quite robust. The number of complaints raised for the corruption, etc., has gone down in the system. So it means the contracts are being modified with the time. This is my short point.
This is for the another topic we discussed before this, that participation for the consortium partner in the dispute. I want to just share my experience in that. There was a consortium of Indian entity and foreign entity, and the dispute was related to Indian entity only. So Indian entity invoked the clause, but the other party told that both consortium partner together is called as contractor. So the contractor has to file the petition or to invoke the clause. So then after that, the consent was taken from the another consortium partner. Then we started the arbitration. So my experience is that always try to take the consent from the other consortium partners, then invoke the clause. So I wanted to share that. Thank you.